So let's talk about patentability, patentability of your invention. What does patentability mean? Patentability, the word patentability by itself may be meaningless. What do I mean by that? Well, let's get into it. Your invention and your patent is going to be determined by the claims of your patent application. The claims are the name of the game. Without the claims, there's no invention. The claims define what your invention is. They define the scope of your invention. For more details about what a claim is all about and the difference between independent and dependent claims, take a look at this video linked here. Now, in terms of starting the draft of your patent application, whether you're doing it yourself or you're working with an attorney, the attorney has to do what's called invention analysis, or you have to do invention analysis. And your invention is likely going to be composed of different aspects. So the circle that I've drawn here is a representation of your invention. If your invention is all of the subject matter that's contained within that circle, then these different aspects are going to be parts of your invention. And there are going to be some aspects of your invention that's likely going to be prior art. So the part that I've cross-hatched in red here is prior art. So that's those are the aspects of your invention that would not be patentable subject matter. They may be needed because they may be part of a product that your invention is improving. They may be things that without their presence, your invention wouldn't be meaningful. Your invention wouldn't have a purpose. So your invention almost always will have some aspects of it that are in the prior art. So invention analysis means you look at all the aspects of the invention to see what is prior art and what are the novel aspects. So the portions of this pie chart that I've cross-hatched in green are the novel aspects. So you have 3 novel aspects. Now, the novel aspects are something I sometimes refer to as the novelty nugget of your invention. Your patent attorney, or you, if you're doing the patent application on your own, have to determine what that novelty nugget is. The novelty nugget is going to determine what your claims are going to look like. So this is an example claim, and it's an apparatus. If your invention is an apparatus, of course your invention can also be a method of operation or a process of some kind, but we're going to look at the claim example of an apparatus to simplify things here. So if your invention is an apparatus of some kind, it could have several what are called limitations. Now in this example claim, we have a first widget, a second widget that's connected to the first widget, and a gadget that's connected to the first widget and the second widget. Now it may turn out that the first widget is not novel. It's something from the prior art. The second widget may also not be novel. It may be part of the prior art. It may be aspects that are in the prior art but that are needed to implement your invention. They're needed for your invention to function. Your invention functions in some respect, it functions in some way related to that first widget and second widget. And so without those prior art aspects, your invention would be meaningless. But here, the third limitation is a gadget connected to the first widget and the second widget. So here in the claim, the third limitation is a gadget connected to the first widget and the second widget, and it could turn out that the gadget is the novelty nugget of your claim. That could be the novel aspect. So, or it could be one of several novel aspects, but let's say that it's this novel aspect in the pie chart. That novel aspect, even though there are some prior art limitations recited in the claim, the novelty nugget makes the claim itself novel. It makes the invention novel and therefore makes the invention, as defined by this claim, patentable subject matter. Now I made I made a statement earlier saying patentability can be meaningless. So you're probably wondering, what the heck did I mean by that? What I meant by that is there are different types of claims in terms of what is referred to as the breadth of the claim. A claim can be broad or a claim can be narrow. So what is a broad claim? A broad claim is a claim that defines your invention with the least number of limitations possible. So in this case, this claim has 3 limitations. If the 2 prior art limitations are needed for your invention to operate, then it might be needed to recite those in the claim, even though they're prior art limitations. But this claim generally, with 3 limitations, is what appears to be, at least on its face, a relatively broad claim. Now, let's say that it turns out that your invention is defined not necessarily by the second widget, but by the first widget in the gadget, and the second widget is an ancillary thing that, if it wasn't present, wouldn't be needed for your invention to operate. In that case, you could draft this claim more broadly. An example of what I mean by drafting it more broadly would mean you don't have to include the second widget. In that case, you just say a first widget and a gadget connected to the first widget, and you can get rid of the second widget. Now the claim would be even broader and more valuable to you as an inventor, more valuable to license, and more valuable to show infringement. And I'll get into infringement in another video, but that's an example of a broad claim and how to broaden a claim. Now, what did I mean by patentability is meaningless? Let's say that the 3 limitations by themselves would not be patentable, and so you'd need to add other various aspects of your invention in order to get a patentable claim. So this claim in that case could continue on. You could have a first widget, a second widget, a gadget, then there's something else, whatever that something else might be, and that something else is connected to something in the limitations recited before it, and then there's another thing, another widget or some other thing that's connected to these things. Well, then the question becomes, can a potential infringer look at this claim and say, hey, you know what? These things, I need to have them to make my product work, but I don't have to have that. I can do something else. I don't need this, or I can replace it with something else. Or I don't need several of these limitations in order to make that thing work. In that case, that product wouldn't be infringing your claim anymore. So for more about infringement, see this video linked above.